Yes, welcome to the No Stay Project live from the fortified compound here in Mesa, Arizona. It's episode 35 of the Wednesday edition live broadcast, streaming here on my YouTube channel, No Stay Project, just like the name of the big show. It is September 20th, 2017. Glad to be with you here from the fortified compound. I'm hoping that the video's looking better this week. There's no reason why. Well, it still doesn't look like it's HD, but I'm gonna have to just put up the what I record locally here and just pull the stream. I'm probably gonna have to pull the stream from Saturday's show, the September 16th show, because there were some copyright hits on that because of the bumpers. I'm imagining because it's the bumpers. Also, I didn't realize that when I was somebody had Skyped me a link about the about Braveheart, about somebody owning an island. I listened to that. That came out over the stream, and I'm sure that that is another reason why there was a copyright. So there was no action taken, but there's going to be ads on it, and then it's not going to be available all over the world. So it sucks to have to pull that because there is about 1,000 views on that already. So I'll have to see. I'd rather not have the copyright hit. I think it's kind of silly. Play a couple seconds of a video and and it's a copyright violation. Give me a break. But a lot of stuff to get to. Expecting a lot of calls today. Well, at least a few calls. The number here is 218-632-9399. 218-632-9399. The passcode is 2020 with the pound sign, or 2020 with the hashtag, depending on how old you are. But that'll get you in. Also, Skype is available. Don't instant message me first. Things are a little bit different here. For some reason, cannot figure out why the hell I cannot connect to my caller line, the Free Conference Pro, on the Windows machine. So the trusty Macintosh is the one that will host the Skype calls. I don't know. I don't know what that's about, but the Skype is Frank Rizzo with the number 3. That's Frank Rizzo with the number 3. And so in the spirit of what we do here at the No Stay Project is to give people the tools necessary to defend themselves effectively against these people who call themselves government. And we use basically what's called the Socratic method, where we just use basic principles of logic, that being that whoever makes the accusation bears the burden of proof. And I like Hitchens' razor, of course. It's very, very appropriate when we're talking about politicians. That which can be asserted without evidence can be dismissed without evidence. Now, I know people with government have guns. So they believe that the gun and threats of violence somehow a substitute for their proof, that they can make claims, they can make assertions, and they just have to threaten you, and and that somehow makes it true. No, that's why we're anarchists. We reject that. So what we do here at the No Stay Project, and I appreciate everyone new tuning in, is to defend ourselves effectively, starting from, of course, not only logic, but from not having a sacred cow, not assuming that just because a police officer said something or something that was taught to us in school about government is necessarily true. Jurisdiction is a very big part of this, because they are accusing you of being subject to their jurisdiction, and therefore their rules and laws, special laws, apply, and we don't accept that at face value. I don't think that any of the prosecution's claims, any political claims, should be taken at face value. Always, always verify, verify, verify. So jurisdiction being based on, hey, if you're physically in Arizona, you're physically in the United States, our special rules, because there are supreme rules or supreme laws, because they love their hierarchies. They believe that a written instruments that nobody bothered to sign actually apply to you. Now, there was some recent things going on, and I can't accept that somebody who identifies as an anarchist would see any validity with the rules. But the whole thing about Well, if the man with the gun is applying it to you, there's your proof that it does apply. And like I've mentioned before, it's not just that they are applying and saying that these rules apply to you and using guns to back it up. They're saying that they create obligations. So they want to just conveniently leave that part out of the equation for some reason. Oh, I think I know. Oh, because it it shows how stupid their claim is. It's how does forcing a written instrument on somebody create an obligation? Now, we reject as anarchists the notion that might makes right. So there's no validity to that. If you think there is, then call 218-632-9399 and fill me in on the evidence that you have, the logic or the rationale, how using a gun and forcing someone to comply with a written instrument actually creates an obligation on them to do that. Again, I reject the concept of might makes right, because if I wanted to, I'd be fully morally justified in putting a gun against someone's forehead, and if they didn't back off to, send them to another world, if they didn't stop using aggression. So this idea that aggression creates obligations, no, I don't get that. It's the same thing we spoke about last time with one of the callers, this idea that might makes right, that right of conquest. It's an anarchist actually saying that you can get property rights through conquest. I don't accept that, and neither should you, especially if they are going to be accusing you of violating their precious code. So I'm hoping he's going to call, give us a first-hand account of this, but until he does, Chuck did not, he really stripped out the nuts and bolts of the motion to dismiss. One of the things we don't want to get caught doing is not just saying, giving conclusory statements. File the motion, give this, so it has the history, has the citations that unfortunately we have to, put in there most of the time. You don't want to just make conclusory statements other than the prosecution has no evidence. But I would spell it out a little bit better than that. So what Judge Michael Joseph Grattan III, and this is going on in Mesa County, Colorado. It's Grand Junction. So what the judge did here was he says the court has reviewed the defendant's motion. The court understands that the defendant questions the validity, some or all, of the statutes of Colorado. No, apparently you did not understand, because if you did understand the motion, then you would have gotten that it was not a question of constitutionality or the validity of the statute. It has to do with the police officer's claim that they apply. That's what it's about. So this is what is called a straw man. What you do is you deliberately misstate your or the other person's position, so it's easier to defeat. And if I'm not mistaken, I think we may actually have Chuck online. So let's get him up here for a first-hand account. All right, we have Chuck in Colorado. Hey, Chuck.
Marc, you there?
Yeah,
Yeah.
Hey,
You there?
yeah, I'm here.
Hey, what's going on, man?
Hey, not too much. Just starting to get into, I didn't notice there's a caller line, but just starting to get into what we spoke about the other day regarding this little traffic situation. So,
Right.
what I just mentioned was, of course, the judge straw manning, saying that he thinks he understands your position and that you're questioning the validity of the statute, in a sense, which is the same as saying that you're challenging whether the statute is constitutional, and that is not what you did, is it?
No, that is not what I did. I asked him specifically on the motion. I said, you know, do the laws and the code apply to me because I'm physically in the state of Colorado? And I find the response from him is he's just basically avoiding the answering my questions, and he still hasn't gotten any evidence from the DA.
Well, he won't be able to get any evidence of that. What he says here, that he says, questions the validity of some or all of the statutes of Colorado, questions the validity of the complaint against him. Well, he's got that part right. You got to give him that. He's got that right. And asserts that the laws of Colorado, he missed a word here, asserts that the laws of Colorado don't apply to him because he is in the state of Colorado. That's not actually what was in there. And he actually says, see motion generally. Well, you got one part of it right there, Michael. The court denies the motion because the court will abide by and enforce those statutes as best the court understands them. That doesn't sound like a response to the motion. Does it to you?
No, it doesn't. No, it doesn't send anything. He's not answering it. That's basically what it is. I mean, it's not his job to answer, but it sounds like he doesn't really have any evidence to answer it from the DA. Like the DA never got back to him.
Right. He's supposed to be making a decision based on the record before him, and which is mainly from the prosecution. He's got to look to see, well, what evidence does the prosecution have in the file here? Let's take a look over there. And, oh, yeah, I see. We got nothing. But instead, what he does, and this is what he does is he uses a straw man again, and just basically ignore. Well, I don't know if it's necessarily a straw man. He denies the motion because the court will abide by and enforce. What he's doing is he's ignoring the actual issue that you raised, that the prosecution hasn't shown any evidence that the police have jurisdiction, that the court has jurisdiction, and that there's any evidence that that the Constitution and rules apply in the first place. He just ignores that and says, well, I'm going to abide by and enforce them as I understand them.
Right. That's not, you can't understand it because you haven't proven that it applies to me at all. So how are you going to interpret anything? That's what I'm saying to him.
I want to continue here. He says that in addition, the court finds the complaint against the defendant to be sufficient, but he's not addressing whether there's evidence that the code applies in the first place. So how does he find that the complaint is sufficient when it hasn't set forth sufficient facts to constitute a public offense?
Right. That's exactly right.
Right.
He hasn't. Yeah, he doesn't. He says that the complaint is my complaint. I mean, even the complaint against me is not signed. Nothing that the cop supposedly said that he gave to me is signed. The cop signed it in custody. He didn't sign. There was nothing else on. My signature is not on any of the paperwork from the officer, as far as like that. So the officer was lying then that he didn't explain anything to me. He was writing up his tickets basically without me.
No, he doesn't need
never
you.
Gave them to me.
He doesn't need you or your signature necessarily. He just needs to, have probable cause to believe that he witnessed a crime, and then he can write the ticket out and have it served on you later or whatever. But he also says here the court finds that crimes committed in the state of Colorado are subject to the criminal statutes of Colorado. Where do you start unpackaging this load of crap?
I know. I'm looking at it with you.
You know, that's the thing. I would have been. I don't think you were clear enough when you filed the motion because you hand wrote on one of their forms, correct?
On one of the forms I did the motion I did before. I believe it was the one in July that I wrote it in hand that the laws, how do they apply to me in the code and stuff like that. I did write that, but they never answered that. They never answered that particular motion. That's the only one that they haven't answered. And then I went with the one that we got from you.
Okay.
I went with that one, and that's the only response I had from it. So it was very clear, written out for what we wanted. In yours, I don't know how he even misses any of it. He's just trying to. I really don't know what he's doing. I mean, he's just.
Well, he's ignoring.
He's avoiding the actual.
There you go.
What you're asking.
There you go. He's ignoring the actual issue, and that is a fairly common tactic that they do. Just either straw man it and attack a different issue that you mischaracterize the person's issue, or you just completely ignore it. in addition, the court finds that crimes committed. Well, all right. Well, let's just say what did he find that based on? Was it evidence from the prosecution? Because I failed to see it. And he doesn't actually spell it out here. He says, well, I find that crimes committed in the state of Colorado are subject to the criminal statutes of Colorado. Where's the actual evidence to prove that that's true? Yeah, you're agreeing with the prosecution. We get that. That's common. But where's the actual evidence from the prosecution that actually proves that that's true?
Right. That's what I want to ask him when I go back in. I want to ask him, what evidence are you relying on to state your answer to my motion? Because I still haven't received anything. I still haven't received any evidence at all based on what you replied to mine. Is basically, where did you get how did you make a determination or a decision based on? I don't see any evidence right here. I don't see any.
No, and
so he just avoided.
I know when we spoke that there was, you told me there was some ex parte communication between the prosecutor and the judge. Can you discuss that and describe that?
Sure. Before I went to pretrial, and they usually put you in a room with the DA, and they try to make a plea with you or talk to you or try to get some information out of you that is not on the record, basically, because it's not on the record. And I went in there, and they offered me a plea. I respectfully declined the plea. I said, no, thank you. I'd rather see the judge. And she said, okay. I said, okay, that's fine. And she hesitated for a moment. And the DA was writing something down. And I said, can I go? Am I going to the courtroom now? And she says, yeah, you go see the judge. I said, that's fine. She handed a note to the sheriff that was standing behind her. The sheriff followed me out of the pretrial office, followed me into the elevator, followed me up to the courtroom. I asked if he was following me, and he said no. And I said, well, that's funny because he seemed to be following me the whole time. And he went to the courtroom just like me. He opened the door for me. I went inside. I sat down. They called my name. I go up there. At that time, the officer approached the bench, gave the judge a note, and sat back down. The judge read the note on the record. He said, I see here now you're a sovereign citizen. That doesn't mean anything to me. How can I help you, sir? So I didn't know what was on the note, never seen the note. They didn't offer the note to me. So basically, he's trying to paint a picture on me that's not true. All I'm doing is challenging with, I think, pretty basic law, and he's just trying to paint a different picture, just like you were saying before.
Yeah, it's and he knows exactly what that means. He played it off pretty good, probably because it was so bad that it was an ex parte communication from the prosecutor's office, and to smear you like that. Because sovereign citizens are described as, or I think they've been classified as domestic terrorists. Whether they're involved in any terrorism or not is irrelevant to these people. Oh
yeah, there's big problems if you're labeled a sovereign citizen for sure.
Yeah, and
I looked them up on the internet. It's bad. It's not exactly. You don't want to be that in the courtroom for sure, because they have a set of beliefs that think that it's like saying it's just discrimination 100% on your belief system. It's not my belief system, but I'm just saying they're painting a picture of my belief system and trying to make me like I'm going against the court. I'm doing everything wrong. I'm just here to harass or whatever, and I'm not. I just want some answers to some facts that I stated. I put them in the way we're supposed to do it. I did everything right, and I just get more. I was slandered by the officer when he pulled me over. I just asked him what was the crime I committed, and in his report he said from after that I asked for backup, and he determined at that time that I was a sovereign citizen. After that, I just asked him, what crime did I commit? That's the only thing I said to him. And after that, I was pretty much physically removed from the car, thrown to the ground, blah, blah, blah. Jeez. And so that got around, and the DA said it, and then the judge said it. So they're painting, it's going around, I'm labeled now.
Yeah.
And that's a very, very big problem.
It is. It definitely is. I know that there's some few things here I want to address on the chat, on the YouTube chat. I do want to point out, I asked you this, and unfortunately there is something in your paperwork that they can hang their hats on as far as connecting you to sovereign citizens.
And what would that be?
It would be where you wrote number 6 on the handwritten motion. And number 6 says right to travel, Thompson v. Smith, and then there's a couple of other court cases.
Also, I cited court cases. That's a problem?
Well,
I was unaware of that.
No, well, all right, there's a couple of problems with that. We'll get to the sovereign citizen thing in a moment. The problem that I have with that is I don't think that making legal arguments such as you guys are not interpreting the laws correctly, I think that is a losing way to go. When it comes to legal interpretation, they don't give a damn. They could not care less. Okay? They don't give a damn. So that's my problem right there. So even if what you cited was true, it doesn't matter because it's not a very effective way to defend yourself. Legal interpretation will always lose. It is always a loser unless you've got a very high-priced attorney and you're spending tens and tens of thousands of dollars to get an appellate panel to reverse. You're going to lose most of the time. The other main problem that I have with it here is when you make something like a right to travel, that puts you right smack dab in the middle of patriot, sovereign citizen, freeman on the land crap. And that is a oh gosh, that is a huge red flag for these people. So from now on, never, and this is for everybody, never, ever, ever, ever argue right to travel. If you go through and you see any of when I discuss this with actual bureaucrats and you know the prosecutors, I never discuss right to travel. That is like a scarlet letter, and it got you branded. Well, you were branded with that by the cop at the stop. So the cop had nothing to go on there. He was just saying that because you asked him that question. And only terrorists ask questions, by the way. You then gave them something in writing here for them to, draw a connection. So we don't ever want to do something like that. The only time we're making, in fact, we shouldn't be making legal interpretation type arguments ever. If we're going to make a due process claim, it's based on, let's say, a lack of a fair trial, that there was a denial of effective cross-examination. That's not a matter of legal interpretation, though. That's a matter of fact. So we have to lay out our facts. Well, if you're saying he denied you effective cross, what evidence do you have? I say, well, I asked him if he saw me violating the law and that he believes the laws apply to me. He said yes. And then I asked him, did you determine on your own that just because I was physically in Colorado that your constitution and laws apply to me and you had jurisdiction? He said, well, yes. And then all I did was ask, what evidence, if any, did you rely on to prove that just because I'm physically in Colorado, your laws apply to me? And then the prosecutor objected on grounds that it called for a legal conclusion. The judge granted it and refused to allow me to ask any more questions. Those are the facts. Those are the actual statements and words said that support the denial of effective cross. Because asking the judge for facts, asking the police officer for evidence his claim was based on is perfectly legitimate on cross-examination. It goes to his prior testimony. You just want him to support the claim he made. For them to turn around and then object on grounds that you can't ask a question that calls for legal conclusion when you ask for evidence, and then for the judge to grant it and not allow any more questions is to deny effective cross. So that's the difference between just quoting Thompson versus Smith saying, I have a right to trial, but you can't do this. That's legal interpretation, and it's not based on any kind of evidence. It's based strictly on what the laws say. So there's a huge difference, and so hopefully everyone can see why we want to stick to questions of fact and law and not just questions of law.
Well, I would say even go a step further with my mistake. I would say that always put the burden of proof on them, because that's what I did is I made a legal determination from there. And that was a big mistake. I got caught up in looking up stuff online with the Supreme Court. I just was looking at cases.
Yeah.
So that's why according to you, I see it now. I didn't see it then. But yeah, I should have just stuck with the burden of proof on the officer, on the court, and stuff like that. So yeah, I could see where it's going with that. Yeah. Yeah. Is there any recourse for me to get out of that or something like that, or what would you do?
It's already been denied, and so it's not an issue that you want to raise again. What you want to do is stick with what you've already what you've done, Okay, you filed the actual formatted motion to dismiss, and it's got the it's got everything in there that we need. So I would stick with that. What we spoke about, and I should have it over tomorrow because I just got this from the UTA. We are going, and this is for anybody who's in a situation like this. If the judge turns around and denies the motion to dismiss or the demur, or the application to dismiss if you're in Canada, you want to file them, and there's no actual evidence or citations to the record to support denying the motion, then you want to file a motion to reconsider and point out that the judge, that one, the motion to dismiss or the demur is based on a lack of evidence. And the judge's denial, like you see here, Chuck, doesn't actually spell anything out. He gives conclusory statements. Well, I find that the crimes committed, are subject to the, but we already know that. We already know that that's the prosecution's claim. We know that that's what the cop is claiming. We want the evidence it's based on. So the motion for reconsideration brings that out and shows that. Here, you also have, you've got ex parte communication with the judge and the prosecutor. You watched it. You witnessed the cop give a note from the prosecutor to the judge accusing you of being a sovereign citizen. The judge actually said something from the note. So that's a big issue, huge issue. I think I mentioned to you where there was a judge in Texas. Maybe somebody on listening can verify this. There was a judge who was caught texting a prosecutor in the middle of a trial.
That's insane.
It's astounding to me that if there was any justice whatsoever, once they saw that the judge was actually texting the prosecutor should have ordered the police to arrest the judge on the spot for obstruction of justice, committing a felony right in the middle of the courtroom. And you obviously you'd have the phones as proof, and you have phone records as proof. Oh man. So that should be in the motion to reconsider, even for a motion to dismiss for prosecutorial and prosecutorial misconduct. That prosecutor had no business sending a note like that to the judge.
Right. That's total undermining of everything. Even, I'm not letting her off by no means. I just think that's 100% it's improper communication between the DA and the judge. It's just totally wrong, 100%.
Oh yeah. So that's what
to do it right there.
How bold that was. And I don't think a cop can claim, and with any merit at all, that he or she didn't know that ex parte communication was illegal and grounds for disbarment and for a mistrial. No, he knew. That cop had to know, or was reckless in not knowing. You don't take notes from the prosecutor and bring it to the judge. Could you imagine if you did that?
Right, exactly. You couldn't even approach the bench; they'd have you arrested. What are you doing? You need to stand over there or something. Seriously.
Yeah. Imagine
it's bad.
But imagine even if you did give imagine you wrote a note to the judge, gave it to the bailiff, and said, "Could you please give this to the judge?" The judge would fly off the handle saying, "Absolutely not. Are you out of your mind?"
Right. That's what he would say.
But they get away with it. They get away with it in Mesa County.
Do. Yes, they do. They think they go by their own set of rules, which, they do. You don't mean nothing. And actually they probably think that you're stupid or something, or you're not going to say anything, or, a lot of people don't stand up, but you got to be in there to see it. You really do. Sometimes you have to press the issue, but she was just mad that they didn't take the plea, because they're in there to try to save the court money from, just making a plea with you so you don't get, your day in court. You still get the fine. You still get money to do it to some other person out there.
Yeah.
And that's what they do. They just try to railroad you.
Yeah, and I'll say it again. If the prosecutor had evidence proving that their written instrument called the Constitution applied to you just because you were in Colorado, they would have just given it to you and you could have made a deal, which is what they wanted to do. But
right. It's just real easy.
Yeah.
If they would say it, they would do it. If it was right there, they would have it. It wouldn't be that hard. They do it every day.
Yeah,
they should know it.
They insist that their rules apply, so just provide the proof. That which can be asserted without evidence can be dismissed without evidence. But unfortunately for us, we have to go through this charade till they realize that it's too much trouble to keep getting hit between the eyes with a request for evidence and they let it go. But this ex parte communication may actually be all that's needed to get this thing tossed out. So hopefully that's what happened. So I will get with you off air probably tomorrow and get you a copy of the motion for reconsideration and a motion for to dismiss for prosecutorial misconduct. Do you have any other questions?
No, I was just saying you had sent me a link to take up a claim with some of that, but we'll probably go over that tomorrow, right? Is that right?
We can, and yeah, and the link that Chuck is talking about has to do with Mesa County, Colorado risk management, so that you can file a claim against the state actors, the judge, and especially the prosecutor, for bringing these charges and relenting and not withdrawing once they realize they don't have evidence, and obviously damage to your reputation by calling you a sovereign citizen.
Right. I mean, it's very insulting. I mean, I'm actually mad at myself for making that mistake even coming out, because I think I'm fairly knowledgeable, but you know, everybody's, you know, you get caught up in the thing. You got to be careful.
You do.
Be real careful out there. So
keep the burden of proof on them. Don't lead with any kind of legal conclusions, and certainly not any legal interpretation. So, yeah, that gets to what we were talking about regarding claims against their insurance, and also misconduct complaints with their office and the Bar Association and the county commission regarding this ex parte communication and the lack of evidence, and bringing a claim with a lack of evidence. So what we talked about on Saturday about really getting going on the offense, and not just being passive and filing motions, but actually filing complaints. And if the insurance claim is denied, which it will, then bringing it into court, and it will. There's no doubt there. And so what I mentioned to you was what we could do is, once we get into court, if we can get past the initial motion to dismiss, which I think you got a good chance of doing, then you can get the prosecutor and judge on the subpoena to appear at a deposition. So that would be sweet. But we'll talk more about that probably on this coming Saturday show. I guess it would be the 23rd. So, all right.
Okay. Yeah, not a problem.
I appreciate.
Well, Mark, I appreciate all your help. I do appreciate your time, and you give great advice. I just want to thank you for that. I appreciate it.
Well, I appreciate that. Thanks for saying. I don't know necessarily how much advice I give other than make all your court dates timely, but I just want to point something out. I'm going to get to a call. I think we got a caller in Los Angeles, and before that, I got to mention JPTAG33 is saying in the YouTube chat, not much going on in my chat there. What the hell's going on, guys? Oh, you guys are probably in another room. But saying that taxation isn't theft because you consent to be taxed, LOL. Really? You consent to be taxed? You're laughing out loud? Okay. Educate yourself in law, then become sovereign and follow common law. Educate yourself. You people need education on language. Crime. Criminal means statutes. Damn, people, wake up. You are a U.S. citizen if yes, your employee and gave up your rights and in commercial laws. Taxation very well is theft, because you're pointing a gun or threatening a perfect stranger to give you money under threat of jail or ultimately death. So when you force people to give you money, that is robbery. That's theft. So this idea that you consent to be taxed, no merit whatsoever to that. Now, and as far as common law, taxation is allowed by the common law. So I don't get that. There is absolutely no evidence. No evidence. No, sorry, taxation is theft. When you force strangers to give you money, even when you do that on the false pretense, when you trick them into signing documents, you're still forcing them. So, no. just because they're classified as and they've been a corporation, you don't have to look up Title 28, Section 3002. There is a Supreme Court case from the late 1790s that the United States government has always been a body corporate and body politic. So that doesn't mean that the taxation, that when they force people to give the money, that's any less theft. So it doesn't matter. I can't get into that right now. Someone like that has to call into a live broadcast. So I do have a caller I want to get to. We have area code 323. You're live on the No State Project. What's your name? Where are you calling from?
Hey, how you doing? My name is Enrique. I'm just calling out of Los Angeles, Linwood, California, to be exact.
Oh, welcome. You said your name was Rico?
Enrique.
Oh,
Enrique.
Well, welcome to the show, my friend. What do we have for you today? Well, what do you have for us today?
Thank you, mate. For sure, man. I appreciate you taking my call. I know a lot of people call me trying to bug you for questions, and I appreciate you taking time to take mine.
That's what we do.
So,
what can I help you with?
It's kind of, so I'm like, I'm dealing with the, same thing in courts, and so I've never had a driver's license. I'm 28 years old. I've never, ever had one. I've never applied for one. I've just always been, I guess you could say, traveling without it. I've been pulled over countless of times. I've got a bunch of tickets, and I never went to court for any of them.
Oh no!
So just recently, I got a ticket at my job. I work at the VA hospital. I got a ticket by one of the police officers that does the patrolling and takes care of the property or whatever. He pulled me over for whatever reason. Pulled me over. He gave me a ticket, and I got a ticket going to federal court, one of the district courts right here in downtown LA. So I went to it, and that was the first one I went to. All the infractions, all the tickets I had. So I went. I took my papers. I took a couple of affidavits trying to turn them into court. They didn't accept them. What happened was I went in. I didn't step in as surety. They didn't want to claim the name. I said I was here as the authorized representative for Enrique Ariola. They said, well, and then we went to the play game.
Enrico,
the person on the paper.
Enrico, I gotta stop you there.
No, it's okay. No problem. Go ahead and stop me whenever you need to.
What do you, haven't you heard me debunk this name stuff for the last, I don't know how many years, that there's no merit to that whatsoever. Nobody has ever produced a single shred of evidence. Yeah, I know. They got Black's,
right.
They got Black's Law Dictionary. Hell, I got a Black's Law Dictionary up there too, capitis, de minimis, and all that. But no one's actually showed, other than the Law Dictionary, no one has ever shown that there's any validity to that claim at all. Zero.
Oh, okay.
So,
okay.
Like what happened with Chuck, you've probably been labeled a sovereign citizen at this point.
Wow. And that's actually pretty bad, right?
Well, yeah, they consider sovereign citizens domestic terrorists. They believe you're some kind of right-wing extremist, and that you're extremely dangerous to the police department. Yeah, it's bad. It's really bad. So, what was the?
You know what? That's probably true, because I went to court a few days ago for one of the other tickets that I had. I went to go reschedule to get an extension for a later date, and man, when they pulled up my thing, I could have swear like 3 of the clerks just went up to my thing and just started reading. It was like, I could see it in their eyes. They're like, man, what's going on with this thing? Why are we reading this? And then it was kind of funny to me. Kind of gave me like a little red flag. But wow. Okay, well that's what I get, I guess.
Well, did you make any others? Did you make any other sovereign citizen type arguments besides the name game? Right? Did you do right to travel?
No, actually, no. All I did really is I went in and I said, oh, well, I am Enrique Ariola. I do have that name, but I'm not the all capital. What I said is that I wasn't the all capital names, and I do have like the English appellation, Enrique Ariola. And then we started going into that game. Oh, are you the person on the paper? Well, I'm like, well, that's my person, all capital name. And I'm just here to see who's making the claim against the name, and I would like to see like the verified claim and who did the signature. And they say, well, you're only here to enter a plea of, the same, no guilty, no contest, or not guilty. So I said, well, I'll conditionally accept the plea of guilty upon upon the nature and cause. I'm not sure if I said it right, but of these proceedings, and understand if what was the valid cause of action on this ticket. And they said, well, I'm not going to force you to enter a plea of guilty, so I'll just enter one for you. And they entered one of no guilty. And I said, well, I object to that. You know, I just told you I'll accept entering the plea. And then they said, well, I already entered a plea for you. And I said, well, you're back too long from the bench. And I said, well, goodbye. And I went down there to the clerk, and then I didn't sign anything. I went there, started arguing that I wasn't going to sign anything. So they just say that they were going to send me something on the mail, and they did. And then I went to the arraignment. I mean, not to the arraignment. I went to the trial, and it went pretty bad because I almost did the same thing. I said I'm here as the authorized representative. And I said, well, are you Enrique Rolla? I'm like, is it spelled in capital names? And I said they said yes. Well, that's not me. Okay, well, a failure to appear. So they gave me a failure to appear. And I'm like, what the heck?
Yeah.
I was just really stunned about what happened. So I go down to the clerk, and I'm like, look, I don't know what's going on, man. I was just up there with the judge. You know, we didn't agree on whatever we didn't agree on. You know, I went downstairs to the clerk, so I'm speaking to one clerk, and he's giving me this blip because I'm telling, hey, man, I don't know if you're going to understand how I'm going to talk to you, man, but I don't know what went up there, so...
All right, well, Enrico, all right, wait, let me jump in here, no problem. Wow, this is horrible. I hope those people listening who are new to my show and to court procedure and whatnot, that is standard operating procedure, especially in California. You're standing right there, and they give you a failure to appear because you play this name game that I can't claim the name. And I'm so sick of hearing that. Oh, the name is in all caps. It's owned by Social Security. They were doing it in the all caps prior to 1935. So, oh, man. And they don't give a damn. Look, and I said this before. They don't care if you have a name or not. Their jurisdiction comes down to one thing. You're physically in Los Angeles. They own you. Okay? Their jurisdiction is based on your physical presence. Whether you have a name or not, they do not care. They don't care. So now you've got an extra charge against you, this failure to appear, because of playing that. So hopefully nobody else would do that. I think what you need to do, what I would do in this situation, I would get...
Actually, what happened, I didn't mean to cut you off. So what happened was I went to this clerk, and, you know, I spoke to one. I couldn't get through him, so they went through another one. They sent me another one. I couldn't get through him. Then I got to this last clerk, and she just pretty much just gave me she said, you know, we're going to give you another trial date. I'm like, okay. Then I said the same thing. Well, I'm not going to sign it, though. And they said, okay, well, then here you go. So they sent me a paper last week, and they said, oh, well, the trial date that you had was an error. We've set you up for an arraignment, and so I have to go for the arraignment for that again.
All right. What date is that?
That's on the 4th of next. I think on the 11th of next month. I'm not too sure, man. I'm sorry, but I have like a few court dates on.
Okay, it's next month. What I would do, I would get the demur. I have a template available. It's crossed over for California. I would get that filed as soon as possible with the discovery request and start role-playing with a script, which I have available too, in the No State Project Skype chat, because we do things radically different here at the No State Project. We actually try, if you remember the last call, if they deny on demur or a motion to dismiss or an application to dismiss, we move immediately into trying to plead guilty so that they don't pull this crap that we're refusing and then plead not guilty for us instead of for a sham trial. All we want to know is, has the prosecution met the prima facie burden by showing any evidence at all that the Constitution applies to me just because I'm physically in California? That's a radically different approach than what you've been doing, because what you've been doing is hurting you.
That's for sure.
They've got you, yeah. They got your number. They got it. We got a live one here. We got someone doing all this stuff. So you're gonna stop all that and start hitting the prosecution where they breathe, and that is their burden of proof, which they which they have. Even in the corrupt system, the prosecution bears the burden of proof. Now, they're going to be under the impression that the prosecution, with the complaint only, has met their prima facie burden, which they have not. And it's your job at the arraignment to bring that out by asking questions. So what we do is, knowing that they have the burden of proof, we just ask questions to determine whether they have evidence and a solid rational basis for their claim. And so they believe that if you're fit, that because you and Rico were physically in Los Angeles, they believe that their Constitution applies. Where's the evidence of that, though? And the moment they put it on the table to tell you what it is, you can just plead not guilty and you know, figure out the fine. But the problem comes in for them is they can't meet their burden of proof. Now, some critics will turn around and say, well, they don't have to do that. Well, that's arguing without evidence. Now, I'm repeating some stuff because you sound pretty new to the material. That's arguing without evidence. So you ask them, so let me, oh, so you're telling me the prosecutor can argue against me without evidence? That's right. Do I get to argue against them without evidence? And then they'll tell you, well, no, really, why not? Why do they get to argue without evidence, but I can't? See, and another thing too, Enrico, is not only are they allowing the prosecutor to argue with you without evidence, they're going to hold that that argument is irrefutably true, that you can't challenge it. Now, does that sound fair to you?
Not so much.
That's not fair. That is evidence of a rigged game. But we're going to be bringing these things out. We're going to be bringing out contradictions in their claims, and in their claims that they are being fair and that you're getting a fair trial. How is it fair if the prosecutor can argue without evidence, but you can't? How is it fair if the judge is forcing you to participate on behalf of the prosecution and is on the same team as the prosecutor? So this is a much, well, let's put it this way.
Yeah, I've complicated for myself pretty much.
Yes, the way I go about doing it, why we've been so successful here at the No State Project, is that the defense is rooted in logic. It's rooted in the Socratic method that the burden of proof is on the accuser. And we don't accept any sacred cows, and we don't allow double standards that, hey, the prosecutor can argue without evidence, but I can't. I mean, come on. That is in and of itself unfair. And you could even grandstand. Say, what if I was to make a legal claim right now against the prosecution and I had no evidence to support it? What would happen? And then whatever they say, then why are you not applying that standard to them? Why is it
holding them to a different standard?
I'm sorry?
You said holding them to a different standard, you mean?
Yeah, it's a double standard. It's not fair. It is absolutely not fair to allow the prosecutor to make a legal claim against you that you cannot challenge, and that you are not afforded the same privilege, that you can't make legal claims against them without it. Because if you accuse the prosecutor of prosecutorial misconduct, you have to have evidence. That's the way logic works. That's the way fairness works. But you see, we can actually provide the evidence that they're arguing without proof because we have the ticket. We've asked them.
I want to ask you one thing also about, I'm sorry, I didn't mean to cut you off, but about judicial notice.
Yes, the judicial notice.
So I was doing some reading, and you know, this is something I was going to do, and if once I did go to trial, give them judicial notice about like statutes and you know, things about the legislator. Maybe if that would help me out, do you think that would probably give me some leeway? When
I filed the discovery and Brady request with the demur, it's also with a request for judicial notice. So a lot of the issues we raise in the demur, I want them to take judicial notice of. I want them to take judicial notice. I think it's under California Evidence Code 451.
51.
I want them to take judicial notice that the court system is adversarial. And then there's a court case to support that. That to be an adversarial proceeding, there has to be an antagonistic assertion of rights. That's a Supreme Court decision. I forget off the top of my head. So somebody has to be accusing you of a legal right that was violated or a legal injury. And that's the thing. If you look at the statute for 1004, the Penal Code in California, they have to have sufficient facts to set forth in a public offense. Well, if they're alleging that the laws do apply to you and that you violated them, they have to have evidence to support that claim. They have to have facts. It's right by their own code. And they don't have any evidence whatsoever that the code actually applies to you in the first place. They're just assuming that. And they'll even tell you that if you ask them. They're just presuming or assuming that. Well, of course they apply. There's no evidence to it. So that's why we put in the judicial notice that their laws require them to have evidence. Their laws require them to have set forth a valid cause of action. Their own Supreme Court has ruled that every court proceeding, every criminal complaint must set forth a corpus delicti, which is the legal injury and the damage, or the act and the result. Every criminal prosecution. And that's not there. So we want them to take judicial notice of that. So I'm glad you brought that up. But when you see what I'm asking for judicial notice of, they're basic principles that are supposed to govern these proceedings, and they're not being done. And they will deny it 100% of the time that we have filed the request for judicial notice. Every single one has been denied. They have even denied. Yeah, now get this, Enrico. This is some scary stuff. They have denied that the California court system is adversarial. That's some serious dishonesty there. They are so afraid of admitting in these victimless crimes, so-called, these mala prohibita. They are so afraid of taking judicial notice that it's an adversary system that they'll just deny it. They actually commit a felony by not doing so because you've given them all the appropriate information, and it says, I believe it's an obstruction of justice not to take judicial notice of that. So for them to not even admit it's an adversarial system, wow. I mean, it was one thing for all the courts I've been involved with in California to uniformly refuse to take judicial notice that there is an exception to the Anti-Injunctive Tax Act. I get that. They're not going to go against the Franchise Tax Board. But to be so corrupt, to not even say, well, we're going to deny almost all of your requests for judicial notice. We are going to take judicial notice. It's an adversarial system. But beyond that, we're just going to... They don't even do that. They don't do that. So I would recommend, I got to take a call before I'm out of time. I would recommend getting the demur package and the motion for judicial notice and whatnot, and a script, and start role playing so that and call into the show again so we can and look at the archives of the show and listen to the call of shames. Listen to the difference in how I'm doing it as opposed to what you and so many others unfortunately have done, and you'll see very quickly how much more effective it is to hold them to their burden of proof and then just ask questions.
Right. Okay. Well, then I will do that. That's for sure, man. I appreciate you taking time to hear me out, and I will call back.
No problem. I hope to hear from you soon. Good luck, Enrico. Hopefully we can get that cleaned up fast because my gosh, people, you cannot go in making these ridiculous assertions. Even if you're right, it doesn't matter because it gets you labeled a domestic terrorist. One day it might come down if somebody questions the applicability of the code, they're automatically a domestic terrorist. I've been labeled that, although here in Mesa, although they said that they got rid of that. But who can believe a word that these people have to say? It doesn't. Until that day, we're going to continue, and even after that day, we're going to continue to challenge these people because that which can be asserted without evidence can be dismissed without evidence. Either put up the evidence or leave me alone, right? That's not too much to ask. So we've got a Skype caller. You're live on the No State Project. What's your name? Where are you calling from?
Tom from Missouri.
Tom from Missouri. What can we do for you today?
Oh, I can't believe I'm on the radio, I guess, or YouTube or whatever you do there. Yeah, I have a huge problem. I've been in trouble for 20 years. I've been trying to get it straightened out.
Jeez.
And I didn't do anything about it until they took my job away, kind of like they did yours, you know, and you go into study law and think you could go in there and do something about it. Well, I tried that, and I got the same thing you got. The judge denied it.
Okay. So what was in your, well, all right, so you file a motion. I'm assuming you file a motion to dismiss a complaint. Was it a traffic ticket?
No, I'm in huge trouble. I'm the worst you can be. I'm what you said. What do you do with that kind of a person? I've been listening to you for quite some time, and I'm trying to study off of that and everything. And I put motions and everything in the court. Not to that one though. They wouldn't let me. They put me in jail, and they told me I understood that I could go to court, but they didn't take me to court for that. The judge just came in and made his judgment because I wasn't there. So I lost a job that I had paid for, $500,000 for it. And I lost it because of that. So I had invested all that money in there, and I lost all that because the judge put the judgment for the company.
This is a lot to try to unpack in just the last few minutes of the show.
Oh, yeah, that's fine. I can always call back some other time. I've been listening for a long time, and that's okay. I mean, I can always call back.
Just give us kind of what kind of, it was a little difficult to follow.
Okay, from the beginning,
just the big points.
Some girl charged me with stalking her. So she ended up being the deputy sheriff's girlfriend. So he tried to beat me up one night. So I went to court over that. That was dismissed, luckily. Then after that, one of the cops from what's going on in Ferguson and that, one of the ones up there, charged me with indecent exposure and stuff. So now they've got a charge like that on me. So now I'm registered. So this has been going on since 2000. They've done this to me. And I've tried to do everything I could. I thought, well, I'll go in and study law, and I'll get all this straightened out because now I know how to do it, and everything will be fine, just like you thought. Well, I know everything now. I'll go in, and we'll get this. We have justice on our side. No way.
Well, I haven't said that. I haven't made that claim in an awful long time. After going into court a few times, I realized it doesn't matter how much you know. It doesn't matter how well you can argue. It doesn't matter how good your skills are. These courts are not there to administer justice and be fair. So
they're not.
It sounds more like you need, especially if you've got involved with, a girl who's a friend or girlfriend of a cop. Have you ever thought of getting the hell out of Missouri?
That's what they told me to do, but no, I'm not leaving. But yeah, okay.
Well,
no, I don't want to get out of Missouri.
Well,
I'm out of the country, actually.
Well, I understand. This is I'm pretty much out of time now. So give a call back on the Saturday broadcast. We will be live this Saturday, and we could do a little bit better.
I've been trying to get a hold of you. This is the only number I know. I've been trying to get a hold of you. I've been trying all week, calling all day long, and then finally I called today when I thought the show would be on, and I did come through. So yeah, okay, I could do that.
Well, yeah, we're live on Wednesdays and Saturdays. Saturday's a 3-hour broadcast.
Well, they've put me in jail, and they've taken the bond off and made it $25,000. And then when somebody tried to help get me out, they said no bond. So that's what they're doing to me now. They're not getting me out of jail now. So now I've got an ankle bracelet on for a year already, and I had one on a year before I had it on. So yeah, they're really doing me bad.
This sounds terrible. So all right, well, I got to get more details. So something like this, you can give me some details on an email, markstevens@mail.com, and then call into the Saturday broadcast.
That's the problem. I can't get on the internet. They won't let me get on the internet. They won't let me go gambling. They won't let me do nothing.
Okay, call the show on Saturday. Call earlier. We start at 3 o'clock Pacific time, so you're Central time, so it's 5 p.m. Central time, and just call the same number that you called.
Okay.
And we'll get you hooked up. We'll figure out what's going on and see if there's something we can do to help you.
Okay, I'll do that.
All right, appreciate it.
You're my last resort. I've been trying for 15, 17, 20 years. I can't get help nowhere. I've hired 7 or 8 lawyers, and I've paid over $50,000.
For you and anybody else, please don't ever tell me how much you've spent on attorneys. It hurts too much.
I know. I've heard you say that before. I know.
Yeah.
What are you going to do?
Well, you don't have
a rope around your neck and say, "Well, we'll let you out if you pay us." So then I had to pay him.
Well, that happens. So, I appreciate the call, and I'll do what we can. We'll get more information on Saturday and see if we come up with a plan to help you.
I also wrote to the Attorney General. I wrote to all the Supreme Courts and everything, and I've asked all of them for help, and they just send me back my mail and say, get a lawyer.
Well, that can be a problem. You may have to get something into the higher court, a petition for a writ, but we'll have to talk about that on Saturday.
Okay.
All right. Appreciate the call. Tom in Missouri calling episode, and it's episode, what are we doing here? Episode 35 of the No State Project, live from the Fortified Compound in Mesa, Arizona, September 20th, 2017. And yeah, that's going to take some cleaning up. It sucks. It's probably going to take a petition for a writ, and it's not something that we can get cleaned up in just a few moments. But I just want to. I don't get it. I always talk about 3 hours of 4 hours of anarchy radio. I appreciate people tuning in, but I'm not a freeman. I am not a sovereign citizen. And I'm not a common law guy. I don't do the right to travel. I think it's, even if that stuff was true, I think it's a really ineffective way to defend yourself in court. And I would definitely avoid it. This idea that you're contracting with the police officer, someone who will kill you if you don't stop your car. You're dead wrong. Gosh, this is not a matter of, well, you can't prove negative. You can absolutely show through objective proof, evidence, somebody coming after you using aggression, going through a force continuum, is not trying to contract with you. There's no consent involved. It's not a contract. Where you're forced into it. Yeah, it's not a contract. So I'm hoping we can. No, I'm very familiar with all this Freeman stuff. I've debunked it several times on entire broadcasts on my LRN broadcast. I've had people who were knee deep in that stuff that were even more familiar with it than I am, and we debunked that line by line. There is absolutely no evidence whatsoever to that. Zero. The name in all caps is not a corporation. Corporations have paper trails. It is not a trust. Trusts have a paper trail. No one has ever been able to reduce any evidence of that. And even if they are printing a birth certificate on paper that looks like bond, it's not a bond. And if they're being sold on the open market, there's a paper trail. Send me the paper trail. If it's on the stock exchange, show me. That stuff is easily proven. But I'm not going to waste any more time on this stuff because there really just isn't any merit to that. Because that which can be asserted without evidence can be dismissed without evidence. So if you've got the proof, present it here on a live broadcast. I'd love to hear it. I'm not going to hold my breath, though, because I don't see it happening. But appreciate everyone tuning in to episode 35 of the No State Project. Got a couple minutes over. We will be live this Saturday on the LRN broadcast. So whoever I was not able to get to today, including Tom in Missouri, definitely give us a call during that broadcast. So till then, salud.